few tips now if you want to rely on unregistered design rights. And so firstly, and perhaps obviously, is to make sure that these rights do occur in the first place. So for European unregistered design right, make sure that there is a first disclosure in either the UK or the EU that is not inconsequential, so that this disclosure reaches the relevant sector. For UK unregistered design right, make sure that it is designed in the UK or EU, or by a UK or EU national, or by someone employed by a UK or EU company. Alternatively, you can first market the product in the UK or EU to generate this type of protection. And the second tip is to make sure you keep a good record of the design process and the disclosure. So as mentioned before, one thing that you'll need to do is prove that these design rights exist in order to be able to rely on them. So keeping a good record of who designed what and when. For example, were they inspired by something? Were they designing to a specification? Will make it much easier to prove that these rights exist in the first place. Similarly, if you keep a good record of how and when it was disclosed, that will give you a good record for proving if European unregistered design right was generated by this disclosure. Okay, so now moving on to a more detailed look at registered designs. So, well, what are the differences between registered and unregistered designs? So the first and most obvious difference is that it requires an application to the Intellectual Property Office. So this means filing an application at...
Can we just stop 2 seconds, sorry?
Yeah, sorry.
The slide before the last, before the title slide there, you froze, so I don't think that covered it. Yeah,
right, okay.
So if you could just go through that one again, that'd be great.
Through the whole slide again?
Yeah, please, thank you.
Okay. Okay, so a couple of tips now if you want to rely on unregistered design rights. So firstly, and perhaps most obviously, is to make sure that the rights are generated in the first place. So for European community unregistered design rights, make sure that the first disclosure of your product is in the UK or EU, and that this is not inconsequential, so that this disclosure reaches the relevant sector. For UK unregistered design right, make sure that the product is designed in the UK or EU, or by a UK or EU national, or by someone employed by a UK or EU company. Alternatively, what you can do is make sure that the product is first marketed in the UK or EU. And the second tip is to keep a good record of the design process and the disclosure. So the first thing that you'll need to do if you ever want to enforce an unregistered right is to prove that this right exists. And so keeping a good record of, for example, who designed what and when, and why they designed it. Were they inspired by something? Were they designing to a specification? That will make this much easier. Similarly, keeping a good record of how and when you disclosed the product will help prove that European community design protection did come into force. And one thing to be aware of is that enforcing unregistered rights can be quite expensive, and this is because of all the evidence that is required. So, for example, as we just said, evidence that the right exists, evidence that you own the right, and evidence that it was copied all require proving in order to enforce these rights. Okay, so moving on to looking a bit more detail at registered designs. So how do these differ from unregistered design rights? Well, the first and most obvious difference relative to unregistered rights is that registered design rights require you to register the design. So this means filing an application to an intellectual property office. One of the main benefits you get from doing this is that registered designs provide a monopoly right. So you don't need to show that a design was copied in order to be able to enforce it. Even if an infringing product was designed entirely independently, you will still be able to enforce a registered design right against that product. So registered designs protect both 2D and 3D appearance once again, at least in the UK and EU. Other countries have slightly different rules, and some countries don't provide protection for 2D articles. But for the UK and EU, our Nike shirt, for example, would be protectable with a registered design. So registered designs provide protection that is valid for up to 25 years, at least in the UK and EU. and this is subject to payment of renewal fees, which are due every 5 years. So it'll be clear from this that registered designs provide much longer protection than their unregistered counterparts. Now, some countries do have shorter periods of protection for registered designs, with 15 years being a common term that you will see in some countries. And finally, so registered designs are territorial, and what this means is that you must apply it to each office around the world where you do want protection for this product. So how do you go about obtaining a registered design? Well, as just mentioned, you need to apply at an intellectual property office. If we take the UK as an example, then you have a few different options for how you can go about obtaining protection in a registered design form. So the first option is that you can apply at the UK Intellectual Property Office, and this will give you a UK registered design. For the time being, you can also apply at the EU IPO to obtain a registered European Community Design, an RCD. So this is a registered design that protects the whole of the UK and EU. The final option is that you can apply at the International Bureau for an international application, which can cover up to 90 countries around the world. And you can also protect in other countries by filing directly at their own national offices. So what are the requirements to register a design? The main requirements are generally consistent around the world, and these are that the design must have novelty and have individual character. So novelty means that the design is new, so that there is nothing out there already that is exactly the same as your design. And what this typically means is that you haven't already disclosed your design in a non-confidential way. Now, individual character means that the design is sufficiently different from similar known designs. And if this is something you're unsure about, then a design attorney will typically be able to advise whether your design is likely to have individual character. So some other important UK and EU requirements for registered designs. So firstly, for a complex product, this means something having at least two parts that fit together. You can only protect what is visible during normal use. So if we take as an example our Cadbury's chocolate bar from earlier, you might consider this a complex product because it has two parts, the chocolate bar and the packaging around it. However, in normal use, i.e. eating the chocolate bar, you do see it, at least unless you eat it far too quickly. In contrast, the engine of a car, you don't see this during normal use, which would be driving it around. Importantly, the law defines that normal use does not cover maintenance and repair. So with an example of an engine, while you might see it if you're repairing the car, that visibility is not counted as normal use. So an engine is unlikely to be protectable by registered designs. So another important requirement is that designs cannot be protected where they are dictated solely by their technical function. So if you have only made technical considerations in arriving at the appearance of a product, then you cannot protect it. So for example, the shape of a spoiler on a car, if you have designed the spoiler thinking only about how air flows over it, then its shape is probably not going to be protectable with a registered design. However, if you've given it rounded corners because you thought they looked better, or if you want to protect it in a particular color which you think looks nice, then a registered design probably can protect that product. And so finally, each design application must show one and only one design. So if you design different variants of a product, so for example, a shirt in a range of colors, then each variant can be only protected in its own separate design application. Fortunately, one thing you can do is file what is known as multiple design applications at the UK and EU IPO. So these offer significant discounts in official fees for bundling multiple design applications together into one. So once you've filed a registered design, how will it be examined? Well, registered design applications are not substantively examined by the UK IPO or EU IPO. And what this means is that they will look at formalities requirements, so make sure that the drawings are okay and that you've not included more than one design in each application. But they won't look into whether or not there are any products already out there that could affect novelty or individual character. Now, the good thing about this is that this means that designs are relatively cheap and fast to obtain. However, it also means that validity is not likely to be called into question until you try to enforce your rights against someone else. Now, it's not unusual for a form of intellectual property right to have its validity questioned when it's tried to enforce. However, with registered designs, the fact that there's been no significant validity assessment done at all by the Intellectual Property Office means that it is more important to ensure that your application is right when it is filed. So when should you file a registered design? Well, in general, you want to file a registered design application before you disclose your product. And this is so you protect your novelty requirement. There is one notable exception to this, which is that certain territories provide what is known as a grace period. So this is a 12-month period in the UK, Europe, and US, within which you can disclose your product, and this disclosure will not hurt a subsequent application. Will not affect the novelty requirement for that application. So this can be useful to enable you to gauge the success of your design on the market before you commit to filing an application. However, one thing you should be wary about is that not all countries do offer such a grace period, with one notable exception there being China, which of course could be a likely manufacturing territory for products that may be covered by design rights. So if you were to disclose your product before you'd filed any registered design, then countries that don't offer grace periods, it's very likely that you will not be able to obtain protection in those for your design. Another thing to be aware of if you do rely on the grace period is that if competitors launch their own products while you are still making use of the grace period, so before you filed your application, you will need to show that they have copied your design before you can register and enforce your design against them. So if you cannot prove that they copied you, you may have missed your opportunity to register your design. So an alternative to using the grace period is to use the priority system. So this allows you to file applications around the world and base them on one application that you filed within the preceding 6 months. So you can use this to file a registered design application in a relatively inexpensive country like the UK, for example, before making the decision in another 6 months as to whether you want to pursue this design in other countries. So this can give you 6 months to test your design out on the market before committing to registering the design in lots of countries around the world. So what should you file? Well, a registered design application is based on representations of the design. So these are drawings or pictures like we saw in the examples earlier. Now, usually there are several representations for each product showing the different angles of the design. These representations determine the scope of protection of the design. So what they show and how they show it is very important. There is a lot of flexibility in what you can show and how you can show it to influence the final scope of protection. So as an example, food and drink packaging, you may only want to show the customer facing sides of the product because this is the most valuable part and this is the bit that customers are going to see. We saw this in the Cadbury's example where they'd only shown the top of their chocolate bar wrapper. Another thing you can do is, as we saw earlier, omit certain parts of the design. So we saw on the Cadbury's chocolate bar example, the packaging omitted the brand name and things like that. So that was protecting only the underlying design of the packaging. Now, a design attorney will be familiar with the kind of tricks that you can play to manipulate the scope of protection. And so they will be able to ensure that the representations that you do file are appropriate for your product. If you want any more information, you can head over to our website there. And if you have any questions, please feel free to email me. My email address is there, or contact me on LinkedIn. You can see my handle there on LinkedIn.